Hi, my name is Kendall Tyre. I'm a partner in the corporate and franchise departments of Nixon Peabody in its Washington office. Franchising in South Africa has gained increasing popularity over the years and has really emerged as one of the key vehicles for expanding business operations in that country. The Consumer Protection Act of South Africa was signed into law in April of 2009. It becomes effective in October 2010. It essentially codifies many of the practices that were advocated by the Franchise Association of South Africa since the 1990s. Under the Act, franchisees are deemed to be consumers, and as such they have a number of consumer rights. They have the right to equality, they have the right to privacy, information and disclosure, fair and reasonable marketing. They're also protected against undue influence. The bottom line is that franchisees are entitled to fair agreements. This essentially is embodied in the concept of providing franchisees with a 10 business day cooling off period. Essentially, franchisees can cancel any agreement with a franchisor without cost within 10 business days after signing the agreement if they provide the franchisor notice. Providing franchisees with disclosure was one of the driving forces behind the passage of this act. However, the legislature has yet to determine what exactly is going to be mandated by the disclosure regulations. The new law prohibits any bundling or tying of products unless the franchisor can show one of two things. Either that the bundling results in some economic benefit to consumers, or that the bundling outweighs any restriction on consumer choice. Alternatively, goods and products can be bundled separately and sold at individual prices. One suggestion is that the franchise agreement specifically list what are those goods and services that are essential to the franchise. So you could, for instance, have in your franchise agreement a list of those core products and services and those non-core products and services. The Act basically provides that the franchisor can no longer be the sole supplier of goods and services for the agreement unless, of course, they're related to the franchise. The bottom line is that these changes are going to have a dramatic impact on franchising in South Africa, and that's regardless of whether or not you currently have operations there or you plan to expand. Franchise systems are going to have to audit their franchise agreements to make sure that they're compliant with the Act. They're also going to have to make sure that they have adequate disclosure that are pursuant to and in line with the new regulations that are going to be issued by the Department of Trade and Industry.